Hello, everybody. Welcome out on a Tuesday night to a fabulous seminar. I'd like to welcome you to the Melbourne Centre for Commercial Law's online seminar on European Law Institute's guiding principles and model rules on digital assistance for consumer contracts. And this is the first consumer-focused set of rules on contract automation. And we're absolutely delighted to have here tonight Professor Christian Twigg-Flesner, who is one of the architects of these model rules and is going to talk to us about the themes, the process, and some of the detail that lies behind the model rules, which raise technical policy questions as well as consumer protection for the modern age. Before we start, I would like to acknowledge that we are on the lands of the Wurundjeri people of the Kulin Nation and pay my respects to their elders past and present. I'd also like to acknowledge that the lands of the Wurundjeri people were never ceded and express my thanks to be able to live and work on this beautiful lands that we share in Australia. And I'd also like to pay my respects to any other First Nations, Indigenous or Torres Strait Islander people who may be here with us tonight. So thank you. And it's also my pleasure to tell you a little bit about our speaker. Professor Twigg-Flesner is a professor of contract and consumer law at the University of Warwick. And I know that many of you here today are very, very familiar with his work. Before joining Warwick, he was Professor of Commercial Law at the University of Hull and previously has taught at the University of Sheffield and Nottingham Trent University. As well as managing to write a set of model rules and principles for digital assistance for consumer contracts, Christian is also Deputy Head and Director of Teaching and Learning at Warwick Law School, which is quite remarkable to be able to take those loads and still have this marvellous output. He's the Managing Director of the Journal of Consumer Policy. Many of us are familiar with and fond of that journal. And is also the author of the European Law Institute's paper on updating the Product Liability Directive for the digital age. And as you will have gathered, Christian has a particular interest in consumer law and the implications and effects of digitalisation. And I imagine we're going to be seeing more from him on that. We know here in Australia of his work. It covers English, European, international dimensions of consumer law, and he has published widely on many topics. But without further ado, I will turn over to Christian to hear about the model rules.
Thank you very much, Jeannie, and good morning from Coventry in England. Good evening to Australia. Thank you so much for giving me the chance to say a few words about our project. It has been a long time in the making. We started this work a good 3 years ago when we first talked about the need to look at contract automation, particularly with the advances in AI. And this slowly crystallized into the project we were now able to present in the last month or so. So what I will do in my session is to give you an overview of the model rules and the guiding principles and some of the background to them. I may not be able to cover every little detail because, as some of you who may have looked at the model rules will have already realized, they are quite detailed, sometimes quite complex, but I will give you enough of an overview, hopefully, to stimulate a little bit of a discussion towards the end of this session. So we'll try and not speak for too long, but you have to bear with me for a little while whilst I try and tell you a little bit about the model rules and guiding principles. So let me jump straight in. We've called these the ELI Guiding Principles and Model Rules on Digital Assistance for Consumer Contracts. That was actually quite a last-minute change in the title. For a very long time, these were called the ELI Guiding Principles and Model Rules on Algorithmic Consumer Contracts. But there's a reason why we decided to change the name at the last minute. Partly because in the wider debate around AI, the focus has now shifted to something called AI agents or agentic AI, and our digital assistant idea is a form of AI agent. Let me say a few words about what we mean by digital assistants. And this is just a label we decided to use for the purposes of the Eli principles because we wanted to avoid, for example, using a phrase such as electronic agent or AI agent or agentic system because of the fairly persistent confusion that arises in some of the literature around the law of agency, the philosophical concept of agency, and the computer science notion or the AI notion of agency. These are all different things. And we want to avoid any blurring of the lines. We all know from the discussions around smart contracts how that label has caused a lot of confusion, certainly in the early days. So when we talk about digital assistants, we have in mind a kind of automated system, a digital system, probably an app that you might download onto your smartphone, or maybe an integrated software feature in a physical product. We all know about the apocryphal smart fridge, for example, that can, monitor your shopping and your stock in your refrigerator and reorder food as and when you need it, depending on your preferences on the time of year and so on. Wouldn't that be a fine thing? And so we are taking this as our model. And these kinds of digital assistants could potentially, when the technology is ready for this, be deployed in a wide range of different ways. From basic information provision, which they already do, whether it's your voice assistants or similar, to automatically arranging a contract for a specific item with a set supplier. This is for example, the pattern we've seen with, say, a printer manufacturer that allows for automatic reordering of toner cartridges when the toner runs low, to a more advanced system whereby a digital assistant can actually find the best supplier at the best price for the specific item, to loosening the boundaries more and more, for example, to automating your weekly shop with your preferred supermarket, to finally having a digital assistant that can just roam free and effectively buy things for you when it thinks you need them based on your personal preferences. Now, some of these are already there and they're already working reasonably well. Whether people like them or not is a different matter. But certainly the most advanced version of a digital assistant, where it effectively takes over your weekly shop, where it takes over your holiday bookings and so on, those kinds of things are certainly still very much in the future. But with so much talk surrounding AI agents, surrounding the idea of contract automation now through algorithmic technology, we felt the time was absolutely right to explore those ideas again, particularly in the context of consumer law. Of course, this is not a new idea. The literature on contract automation through software has been around for a long time. There were papers in the late 1990s that played around with this idea, and some of the issues for consideration identified back then are still with us today, and we're still trying to find solutions. So just to explain, finally, here's our definition of a digital assistant. We refer to it as an application using algorithmic systems, which could include AI, that's based on preset parameters, user inputs, and data obtained from a range of sources, depending on how the digital assistant is ultimately designed, is designed to take actions to accomplish a set of predefined objectives for contractual relations. So very much focusing on contract automation. Our project has got a bit of a pedigree in the European Law Institute. My fellow co-reporter, Teresa Rodriguez de las Heras Bayel from Carlos Tercero in Madrid, authored the guiding principles for automated decision-making in the EU a few years previously. We then took over the ideas and developed our own project. And initially, we were asked to focus specifically on how EU consumer law might be in need of adaptation to get ready for automated decision-making in consumer law. This was a report we prepared as the first part of our project, and we published this report in December 2023. It was slightly unusual because we were asked to effectively provide an impact study of a set of rules that we hadn't developed yet. There was a reason for this. We were asked to do this to help inform discussions that were happening at the European level at that time. But for this report, we developed our guiding principles, which have more or less survived in unamended form in the final version. And I'll say more about those in a moment. But following the publication of the report, our original plan had been to focus on algorithmic contracts more generally, but at that point, ANSI Trial had more or less finalized its model law on automated contracting, and a European scholar, Professor Christian Twigg-Flesner from the University of Vienna, had been working on her own principles for AI in contracting. And we decided that we would now continue, therefore, by focusing specifically on consumer law to make a unique and distinct contribution to the field. And this has now resulted in the publication of the guiding principles and model rules on digital assistance for consumer contracts, available on the ELI website. So let me tell you a bit more about the guiding principles in detail. First of all, they have a total of 8 guiding principles underpinning the model rules. And perhaps the most dominant principle is principle 1: the actions of a digital assistant are attributed to the person using it. So we started very much from the assumption that we treat a digital assistant as a tool, not as something distinct from the person who is using it, who has deployed it, but we're using it as a tool, and therefore anything that tool does is effectively something that person does. That's our starting point. As a result, consumer law continues to apply without any impact to the contract that might be arranged through a digital assistant. We don't distinguish between non-digitally assisted contracts and digitally assisted contracts. It makes no difference. Consumer law applies, but the contract is between a consumer and a business and a trader. And this extends also, of course, to the provision of pre-contractual information, which we think is important because there is a debate whether, because of the immense data processing power of AI systems, pre-contractual information will become a thing of the past. One of my fellow co-reporters, Christoph Busch, is exploring this idea very actively. I am yet unpersuaded that we are at that point where AI systems actually allow us to dispense with core consumer protection tools. I think it's actually the opposite that's the case, but there we are. We want to enable the development of a digital assistant market, so our rules are designed to be facilitative whilst maintaining a high level of consumer protection. But this requires, of course, basic acknowledgement that consumers should be able to use digital assistants and that any contract arranged through a digital assistant should be legally effective. And that is stating the obvious, certainly for anybody from a common law legal system where this hasn't really caused any great deal of difficulty ever since Lord Denning's famous ticket machine in Thornton and Shoe Lane parking. Automation has not been a problem for contract law, but it did require stating, certainly for some of the civil law jurisdictions. We're also keen that there is a form of disclosure that digital assistants are used, particularly where this is not obvious from the circumstances. I'll say more about this in a moment. And as another guiding principle, and this is obviously fleshed out in detail in our model rules, we need to make sure that digital assistants themselves are protected from manipulation. We know how easy it is to manipulate the performance of, say, a chatbot through prompt engineering, and this is the kind of concern that we also have when it comes to digital assistants. Perhaps one of the other big principles is Principle 7, and this reflects the overall human and consumer-centric approach of our model rules. A consumer must remain in control of a digital assistant, so there has to be this residual ability of a consumer to intervene. And in particular, this has to be done through the ability to set, review, and amend any parameters which are used by the digital assistant for contracting, through the ability ultimately to prevent the conclusion of a contract. So there has to be something the consumer can do at their own choice to stop the process, and ultimately by being allowed to deactivate the digital assistant, to just switch it off. Now, these are residual controls because the whole point of a digital assistant would be to automate contracting processes. The whole idea is that the human effectively removes themselves from that decision-making loop, but it needs to be possible for the consumer to step back in to maintain some control so the system doesn't run away. So it gives the consumer residual controls and possibilities to intervene. Finally, where there is a danger of conflicts of interest, we make sure that this is disclosed and that the consumer has, depending on when the conflict arises, the possibility of escaping any contractual obligations. Again, more on that perhaps a little bit later. In addition to these 8 express principles, there are 2 disguised principles which permeate the model rules, but we didn't make those explicit in the guiding principles. The first one is the one I already mentioned, that we regard digital assistants as tools and not as anything distinct or separate from the person deploying it. And secondly, in dealing with the detail of the model rules and indeed in our guiding principles, we looked at the novel risks associated with the use of digital assistants, and we are trying to find an appropriate allocation of that risk between all the parties concerned, whether that's the supplier of the digital assistant, the consumer themselves, or indeed the third-party businesses who might end up in the contractual relation with a consumer as a result of the digital assistant's actions. It's about risk allocation, an appropriate allocation. It's not about balancing the risks. It's ensuring that the risk is allocated to the person best capable of managing that risk. And different model rules and guiding principles come together to try and find an appropriate allocation of risk here. In our model rules, we have taken the view that there are 2 distinct contractual relationships we need to examine. The first is the contract for the supply of a digital assistant, because consumers will get their digital assistants from somewhere. And we assume that for our purposes, that digital assistant will be supplied either as an application, as I've said, or as an integrated feature of a smart product, or possibly by being a feature of an online platform. There's a contract between whoever provides or supplies this digital assistant and the consumer. At its heart, this contract is a contract for the supply of software or as a contract for the supply of digital content or a digital service, as is the European and UK terminology, digital content, digital services. So there's already a familiar type of contracting situation here, but we have provided some supplementary rules for that particular contract. And there's the second contract, which is the more interesting one, which is the contract where the digital assistant finds a potential contracting party and then negotiates a contract, or at least arranges the contract on the trader's standard terms with the consumer. There are 3 big building blocks in our model rules, and this is the interesting bit, because as well as having specific rules on contracts 1 and contract 2, the 2 contracts, supply and algorithmic contract, we also have quite detailed design requirements for digital assistants. And we spent a lot of time figuring out how we would best structure our model rules. We started from the idea that we wanted consumers to have certain rights or certain abilities when they are using a digital assistant. And initially we felt, well, we can try and write those as traditional consumer rights, which means they have to be enforced after the event when consumers have somehow suffered a loss or encountered a problem or similar. And then we felt that because of the particular nature of digital assistants and their function overall, we actually needed to make sure there were some ex-ante controls even before the consumer deploys a digital assistant to ensure that any potential risks, any potential opportunities for unexpected or unwanted outcomes are minimized. The nature of the technology is such that it can't be eliminated, but we can certainly try and minimize it by having greater control before deployment of a digital assistant. And we are doing this through our quite detailed design requirements. And I'll say more about this in a second. And then we have some specific sections dealing with, first of all, the contract for the supply of the digital assistant, and then the algorithmic contract. In total, we have 25 articles or so-called black letter rules, together with explanatory comments, and these are divided across 5 different chapters. Chapter 1 provides definitions and the general scope of application. Chapter 2 sets out the design requirements. Chapter 3 deals with the contract for the supply of a digital assistant. Chapter 4, the algorithmic contract. And Chapter 5 contains a single article dealing with potential recourse for a business where a contract arranged through a digital assistant has been set aside or is void because the digital assistant has effectively gone rogue. Say more about this again in a moment. These are our digital assistant design requirements. They are quite detailed, set out in articles 4 through to 10. I won't talk through each of those in detail, but let me just highlight some of the important ones. I've already mentioned when I talked about Principle 7, the need for a consumer to remain in control right before deployment by being able to select a number of parameters within which the digital system will operate, and also to have the possibility of modifying those parameters. This is important. These parameters are not set and then the system runs forevermore. These parameters should be capable of being reviewed. And indeed, where a digital assistant is designed to, for example, take a consumer's digital profile into account, the consumer should also be able to have a look at that profile and perhaps correct it when it goes wrong. And the reason we thought about that is because one of my fellow co-reporters, Christoph Busch, was identified once by an AI system of some kind, by some search algorithm, as being a senior citizen, and therefore was offered a senior citizen's train ticket once, which of course he's only a little bit younger than me, and I'm not quite 50 yet. That's rapidly approaching. So obviously he's nowhere near being a senior citizen. So we felt there was a need to perhaps address the possibility of just checking whether the profile contains some major inaccuracies that would affect the performance of the digital assistant. Secondly, we have the functionality to stop the conclusion of a contract, or to say it more accurately, to prevent the placing of an order by the digital assistant. We changed the terminology at a very late stage because we looked at the way electronic commerce law that's been around for, almost 25 years now in the EU and in the UK, how it looks at the process of contracting. And the moment of placing the order is quite often the crucial point. When a consumer clicks the button and says order now, that's effectively when a consumer has done everything they need to do to arrange a contract, even though more often than not, the actual contract isn't concluded until later. So we use that as our hook. Now, there are a number of ways in which a consumer can stop the conclusion of a contract. One is to require prior approval before an order is placed. So the consumer could decide to set the functionality such that every contract or certain contracts for certain products need to be approved before the order is placed. The alternative is a negative intervention option, an objection option, as we call it, whereby the consumer could let the system run, but whenever a contract is about to be concluded, in other words, an order is about to be placed, there's a slight delay, a message flashes up on the consumer smartphone and says, about to place this order, press stop if you don't want this to go ahead. So there's this right to object. But we also acknowledge for some contracts, for example, ordering transport such as a taxi, we don't want to have delays. We just want the taxi to come, and therefore the consumer could switch this off for these particular types of contracts. We also have the functionality to temporarily or permanently switch off the digital assistant. And this is important insofar as we are arguing that where this is a digital assistant that's integrated into a smart product, that digital assistant should not affect the other functionalities of the product. For instance, if you have a smart fridge with a built-in digital assistant, you do not want the fridge to stop working because you've switched off your digital assistant. It's that kind of thing that we clarified in here. We had the disclosure principle earlier. We think this is a technical question, and disclosure can easily be done through a technical function of the digital assistant. We also say very clearly that the digital assistant and the user interface of the digital assistant has to be designed in such a way that it doesn't manipulate the consumer into setting the parameters in a particular way. For example, steering the consumer towards particular supermarkets, if it's a grocery shopping app or something along those lines. And finally, we have a very broad provision suggesting there has to be some way of documenting the decision-making process. We all know that this is technically quite challenging still, but there has to be some indication of where the digital assistant is looking in order to identify, for example, which particular contract to enter into. Let me move on to the next element, the contract for the supply of a digital assistant. As I said before, our starting assumption is this is a contract for the supply of digital content or a digital service, or in other jurisdictions, it might be a contract for the supply of software. We think there is a need to add some pre-contractual information duties for the benefit of consumers, although we acknowledge the difficulty that's generally inherent in the provision of information to consumers. But we think there has to be at least the possibility for those consumers who want to pay attention to have this information. So how to set parameters, whether, for example, a certain business has preferential treatment. It might, for example, place orders with certain supermarkets, but not with others. How to suspend and deactivate the digital assistant, how the functionality to stop the conclusion of a contract will work, and clarification that any contracts concluded through the digital assistant will be binding on the consumer and the relevant businesses. I already mentioned that when it comes to conflicts of interest, we have a disclosure rule. We decided to settle on this for the time being because there is still some uncertainty around the whole idea of digital assistants and how prevalent they will become for consumer transactions and how they will work. So we decided after some debate to go for a fairly low-key disclosure rule. If it's disclosed before the consumer opts for a particular digital assistant, the consumer may simply choose not to go ahead. If the conflict only arises at a later point, the consumer should have the right to end the contract for the supply of the digital assistant without penalty. And we have provided more detailed rules on this in Article 12 of our model rules, of the model rules. So the kind of situation we are thinking about here is, for example, an online platform providing a digital assistant to a consumer that might also operate in the interest of traders operating on the platform. And if there is a potential conflict, that needs to be disclosed. The right to deactivate the digital assistant is a functionality itself, but there may be implications on the contract for the supply of a digital assistant, for instance, where this is a form of subscription style contract where the consumer pays a regular subscription of some kind for the use of the digital assistant. And what we are effectively saying is, well, the underlying contract cannot be affected by the decision of the consumer to temporarily or permanently switch off the actual functionality. But doing so, switching the system off, should not result in additional charges other than the agreed contractual subscription rate. So that's important. And if there's a variation to the subscription contract where this is permitted, then on reactivating the digital assistant, whatever the then current terms are would apply from then on forward. The conformity requirement, we already assume there is an existing conformity requirement, but conformity must include, in our view, the requirement to comply with all the design requirements. So if a digital assistant doesn't meet the design requirements, it is automatically not in conformity with the contract. And a more general test that a digital assistant is not in conformity if its actions deviate from those a consumer would reasonably expect. And I'll come back to this in a moment. And finally, we confirm that not only that the supplier of a digital assistant is liable to the consumer for any non-conformities, but also, this is important more from a European point of view, although our principles are not specifically directed at the European Union itself, but they are meant to be globally available. This must include an obligation to pay damages for any losses incurred by the consumer. Again, not a problem, for example, from a national law point of view, from a common law point of view. Damages are part and parcel of the remedial scheme. But in EU legislation, this is why we made this explicit. In EU legislation, it has been almost impossible to agree rules on damages, certainly in general sales contracts. And we are stressing the importance of having a right to damages that's consistent when it comes to digital assistance, because the main losses consumers might suffer is being tied into contracts they didn't want, they didn't expect, and which cost them money. And that's the kind of loss that a consumer might need recourse for if this is the result of a non-conformity. Turning now to the contract concluded through the digital assistant, the algorithmic contract. Here again, we have a whole range of different provisions, starting with the basic requirement or statement that contracts concluded through a digital assistant is legally binding, legally effective, and an article that implements the guiding principle that the application of consumer law to the contract concluded through the digital assistant is unaffected. Insofar as pre-contractual information has to be given by the relevant law, we think there needs to be a clarification, which is already quite common in many legal systems, that this also should be available in a machine readable format so it can be processed more easily by a digital process. We have a general duty to disclose that either party is using a digital assistant, except where this is obvious from the circumstances. So, for example, you wouldn't expect an online platform, an online marketplace, such as Amazon or Alibaba or similar, to have to say to the consumer every single time, there's a digital process by which I'm offering my goods to you. It's obvious. Everybody knows it's digital and automated. But it might be the case that a small business may not be so familiar with the digital use, the use of digital assistants by consumers, and therefore it might be useful for them to know that they're dealing with a digital assistant as opposed to a human consumer. We think in almost all instances, the digital assistant will have the functionality to disclose this automatically. So this is really a background, a residual duty. We talked about the functionality to intervene in the conclusion of a contract, to prevent the conclusion of a contract. If the consumer has chosen the objection approach, where there is a brief period of time to prevent the placing of an order, and the consumer fails to act within that time window, obviously at that point the consumer is bound. We're clarifying this as well. And finally, we are talking about information duties, and if the information can be stored or processed or transmitted by the digital assistant, if it has that functionality to store the information that has to be provided under the relevant legislation, then it is enough for a trader, for a business to have provided that information to the digital assistant, even though the law might require it to be given to the consumer. So we are effectively offering an alternative way of providing information, but only if the digital assistant actually has the capability of taking that information in a way that it can be transmitted to the consumer, or at least stored in the digital assistant, and therefore be made accessible to the consumer. And we think this is important, for instance, for exercising the right to prevent the placing of an order, to stop the conclusion of a contract, because for a consumer to decide whether or not to go ahead, it might be necessary to have the relevant pre-contractual information. And then we come to perhaps the most challenging provision, Article 22. This deals, first of all, with the basic rule, if reflected in Guiding Principle 1, the actions of a digital assistant are attributed to the person using it for their contractual relations. This applies to either business or consumer. So both parties, when they deploy a digital assistant, they are, as a starting point, bound by what the system does. Now, we know that some consumers might end up in unwanted contracts, but they have all these control mechanisms already. They have the possibility to set parameters at the start. They have the possibility to prevent the placing of an order. So unwanted contracts they have to live with. But sometimes, because of the nature of the algorithm that might be underpinning a digital assistant, sometimes the system might take decisions, might get to a point where it's just totally unexpected. And so we have a limit to the attribution in the case of consumers. And we are deliberately coming up with a standalone rule that does not tap into any national doctrines of mistake or similar, because they don't really work as they are currently presented when it comes to the use of a digital tool that effectively substitutes the human consumer's involvement in the decision-making process. We have already seen the strained reasoning in B2C2 and coin in the commercial case. We felt we had to have something much more straightforward and bright line. And indeed, in the principles on the use of AI in contracting, drafted by Christian Twigg-Flesner, there's also a rule that seeks to get around any national rules on mistake. Our limit to the attribution to the consumer concerns actions of a digital assistant which deviate from those which could reasonably be expected by the consumer. And crucially, we're using the phrase reasonable expectations to indicate that this is an objective test based on a number of different factors. And we are looking particular at deviations that are the result of the adaptive functionality or any external factors, for example, rogue data or indeed cybersecurity hacks. Where this has happened, the consumer should not be bound. So this is clearly a consumer protection rule. This is setting a limit to the risk placed on the consumer who decides to use the digital system by saying there are limits to that risk. When it goes really badly wrong, the law, the model rules will protect you in those instances. So this is the way we sort of look at attribution and the limitations to it. And finally, because this may affect also the businesses who might have thought they had a contract with a consumer, might have dispatched goods if the consumer of the digital system had ordered goods for the consumer, they might incur losses because the contract now falls away because of the non-attribution, because of the operation of Article 22, paragraph 2. And here Article 25 provides a third-party business with the right of recourse against the supplier of a digital assistant where they have suffered losses that they cannot control or recoup by other means. So, for example, where they have sent the goods out, the goods are in transit, they have to be returned, they have to be restocked, or because they won't be restocked, they are regarded as written off. Those kinds of losses, if they mount up, can cause some serious harm to a business potentially. So we want to acknowledge that and provide the business with a right of recourse. So that, in a fairly rapid trawl through, is a review of the, or an overview at least, of the ELI model rules on digital assistance for consumer contracts. I hope I've given you a nice and detailed enough flavor of what we are doing. Of course, there's a lot more detail in the rules themselves and in the explanatory comments. So hopefully you will feel inspired to go and read them. Thank you.
Well, thank you so much for that amazing exposition of what is a very, I don't think it's long, given the amount of ground you covered, but a momentous document. So thank you so much. We are at time, though clearly we could keep talking. So before I thank our presenter, I'd like to direct everyone to the recent advertising for Amazon Alexa Plus AI, which purports, in fact, to be able to enter into contracts on behalf of consumers. I guess we'll wait and see on that one, as has been suggested by our presenter. But if it is, we have the rules ready to go. I'd really like to thank you, Christian, for just an amazing presentation. It was incredibly clear. It's provoked so much thought and discussion. We really appreciate you staying up. And actually, we're probably going to invite you back again later in another time to talk about how the rules have developed or what you're doing next, I think, because you can see.
It'll be a pleasure. Absolutely.
Oh, wonderful. Thank you. Thank you so much. And you can
Thank you so much. Thank you, everyone.
All right.
Bye-bye.
There will be some slides and a recording. So thanks, everybody. And thank you again, Kristen.